So, Your Excellency, Secretary General Hugo Siblesz, we are very happy to have you here today. I think the keynote address you gave earlier was really inspirational and very important, really to set the framework for the conference as a whole. Now, I just wanted to ask a few follow-up questions based on the speech that you gave and to go a little bit deeper on some of the issues. So if I may, let me begin with the first question, which is, I think, a challenging question, but we very much look forward to your insights. What recommendations would you give for strengthening the capacity for international law to encourage the universal adoption of human rights?
You mentioned adoption. I would argue that already quite a few human rights provisions have been adopted universally. That is not to say that they're being implemented everywhere or implemented in the same way, but there is, I think, a very considerable body of law that has been created over time, and it is to me more a matter of how to implement it, how to make it happen, how to make it part of everyday life. And I think that was also what I meant to say this morning, that in investment arbitration, for example, there is a potential conflict between obligations engaged by the state on the one hand, in terms of attracting foreign investment, and on the other hand, commitments engaged by the same state in the field of human rights, notably economic and social and cultural rights. And there is an interesting trend, which I attempted to describe, where those two fields are where tribunals are seeking to harmonize those fields, to take into account considerations across the board. And I think that's a very promising, even if it's a very difficult exercise. And I would say it's a development that is fairly recent, so the jury is still out. But if you look at various negotiations, for example, in the context of the transatlantic trade and investment partnership, one of the issues there is the protection of workers' rights, and that is something that is definitely of great interest for the general public, for everybody, in fact. And so that, again, in that area, negotiators are looking at those issues, and I hope they will come up with appropriate solutions.
Okay. No, but I think that's exactly this issue as you raised, the problem between adoption and implementation. There are many things, as you said, that have been adopted. A great example of that would be 1951, let's say the Universal Declaration regarding genocide. Now, in 1951, the world agreed, actually, genocide was a crime. The issue is implementation. So do you have a specific suggestion here? I mean, is there a need for a new mechanism, or how can we try to make that a smaller distance between the adoption and the implementation when it comes to human rights?
Well, again, with the international relations being what they are, with the states being still the prime actor, and adoption of any body of law very much dependent on the adoption by individual states. There's I think, an important role for public opinion and NGOs transmitting those views in a more forceful and more experienced way, in a very professional way. And I think that's also a new trend where the civil society is playing its role. And I would hope that would lead to results, both at the level of states taking on obligations, but also, for example, the other example I mentioned this morning, of businesses being involved in producing clothing and the like, creating proper conditions of work wherever their subcontractors operate. I think that's also a very important field where, again, public opinion is an important factor in bringing that about.
Do you see human rights as primarily a cultural issue? And how do you think we can find the balance between universal international human rights law and respect for individual cultures?
To me, human rights are, by definition, universal. But that may be a bias on my part. I would believe that the right of free expression is something that each individual would want to obtain. It may not have the same priority everywhere, in the sense that some people are less well off in terms of economic positions and the like, so they may give a priority to other human rights. But it's more a matter of difference in timing, difference in priorities, than that I would accept that a particular human right is only applicable in, say, the Western world, and that there's a totally different human rights applicable in the East.
Good. Well, I think it's a big challenge to try to have that balancing back and forth. My next question, in your role as Secretary General of the Permanent Court of Arbitration, what do you see as the greatest barrier to ensuring state adherence to international law?
We at the Permanent Court of Arbitration depend on the consent of basically states, but also of other parties involved in arbitration. Arbitration, by definition, requires consent, and that consent may be given once a certain dispute has arisen, or it may have been given way in advance, in the abstract, as it were, when countries conclude treaties establishing rights for their citizens, notably, to initiate arbitration. That is the main, I think, the main challenge. Yeah, that's from our perspective. We're not an intergovernmental organisation, say, that is active in a particular field, creating, together with its member states, creating legal obligations. We are, as it were, an organisation that is at the service of states and entities authorised by states to initiate arbitration. Not only arbitration, by the way, the Permanent Court of Arbitration is also involved in mediation and commission of inquiry and conciliation, and all sorts of dispute settlement. But in that sense, not the primary actor when it comes to creating substantive obligations.
Excellent. My last question is related to cultural diplomacy, going back to the earlier conversation. Do you think, I would say, what role do you think cultural diplomacy can play, both in arbitrating in disputes between nations, as well as promoting human rights?
Well, I'll take the example that I gave this morning of the negotiations on this transatlantic trade and investment partnership. There are many issues of substance, obviously, about the regulatory space for countries in terms of quality of goods, whether or not to accept genetically modified organisms and similar requirements. That is, it's a debate that's ongoing in this transatlantic context. Different peoples have different priorities, different concerns, and that's the challenge to seek a certain harmonization between regulatory systems, for example, in that context, without giving up matters of major importance seen from perspective of the participating countries. So, in that sense, there is a lot to be gained, I would say, by engaging in the dialogue on the importance of certain rules to be agreed amongst those countries on the right of workers, again, the quality of goods, in fact, matters that would normally be governed by national regulatory systems, but would here be kind of be the result of a negotiation on the best model, and on some say, the European perspective might prevail and others, the American perspective might prevail. That's a matter for negotiators to determine. But there again, the underlying need is, I think, for a dialogue, and in that sense, related issues like transparency of proceedings are important as well to make this a credible mechanism.
Good. Well, thank you very much for taking the time to come and to speak, and also for the interview.
Okay.
And we look forward to hopefully staying in dialogue and hopefully collaborating in the future.